former President Jacob Zuma made several sweeping and contentious claims to supporters gathered in Nkandla yesterday and repeated some of those at a media conference held in the evening. Hundreds had descended on the area to show their dissatisfaction with the Constitutional Court's decision to jail Zuma for 15 months. This is for contempt. Well, let's unpack some of these statements. We're joined now by specialist legal reporter Karyn Maughan. Karyn, good evening to you, and thank you so much for your time. Of course, what we have seen coming out of the president yesterday in the multiple addresses that he gave is that the former president still very much identifies himself as being a victim of what is a cruel and inhumane legal system in this country that has not given him an opportunity to a fair hearing.
Well, absolutely. And a key ground for the inquiry's response to that is to track over 21 pages in an affidavit that was filed yesterday, the painful and very long history of the Commission's attempts to get Zuma to come before the inquiry and answer questions, initially by repeatedly inviting him. Of course, he only came once in July 2019, and subsequent efforts to secure his attendance were met with refusals largely on medical grounds, Jacob Zuma saying he was badly and very unfairly treated in that regard. But then when it came to the Commission's application to compel him after he walked out of the inquiry in November 2020 because DCJ Raymond Zondo refused to recuse himself as the inquiry chair, he then chose to not involve himself in the process at all in terms of, trying to make an argument that he did not need to be compelled. He says now that that was a completely unnecessary application. And then subsequent to that, defying the Constitutional Court's order that he appear, refusing to answer questions at the inquiry, when he was pursued for contempt, refusing to participate in that case, and after the Constitutional Court, actually 2 weeks after it had the contempt hearing against him, sought his input on what possible sanction he should face, he did not choose to provide any evidence to the Constitutional Court, instead writing a 21-page letter to Chief Justice Mogoeng, in which he again, as he has continued to do, compared the highest court in the land to the apartheid state and painted himself as a victim who was, quote unquote, ready to become a prisoner of the Constitutional Court. Now, the inquiry saying in that circumstance that Jacob Zuma's assertion, which is obviously very laden given South Africa's deep and politically divisive racist history, to compare what has happened to him to the apartheid government's detention without trial under the state of emergency is simply untenable. It's factually and legally untrue. And they're saying that, Kathy, the court hearing his attempt to stay his arrest tomorrow must dismiss that application out of hand.
Well, just speaking on the issue of being jailed, the former president Jacob Zuma describing his 15-month prison sentence yesterday as shocking, and as you heard from Karyn, that it's reminiscent of the treatment he received from the apartheid government.
Yes, I mean, this was an extraordinary submission because he compared also the COVID-19...
A punitive jail sentence without trial is something which should induce a sense of shock to all those who cherish freedom and the rule of law. Contrary to the mainstream the mainstream narrative and propaganda against me, I've never refused not to appear before the State Capture Commission. In fact, the disagreement or discomfort from my side arose when I was in the attendance at the State Capture Commission.
Well, Well, let's take you back now to Justice Sisi Kampepe delivering the judgment last week, and in particular on this very matter of why it is that the president was being found guilty by, this is for contempt of court, by the Constitutional Court.
The Constitutional Court holds that there can be no doubt that Mr. Zuma is in contempt of court. A judgment and order was handed down in favor of the applicant in CCT 295/20. Mr. Zuma was served with the order, and it is impossible to conclude anything other than that he was unequivocally aware of exactly what it required of him. Mr. Zuma failed to appear and give evidence before the Commission on the date so ordered, and similarly failed to file an affidavit in accordance with the chairperson's directive. Mr. Zuma is therefore in blatant violation of the court order made in CCT 295/20. To his peril, Mr. Zuma has not presented any evidence to establish a reasonable doubt as to whether his disobedience of the order was willful and mala fide, and the extent to which Mr. Zuma has attempted to justify his defiance through public statements is of no relevance. The statements were not formally pleaded, so fall to be disregarded. The Constitutional Court can do nothing but conclude that Mr. Zuma is guilty of the crime of contempt of court.
So just in her own words there, Justice Kampepe saying, well, this was an act of defiance by the former president not to appear before the Commission. Why then is it, Karyn, you think that he continues to say that he never refused to testify at the Commission?
Well, this is part of a wider pathology. I mean, Jacob Zuma has adopted the same approach in relation to the contempt case that he faces by the NPA. He essentially says that the NPA is too biased to triumph for corruption. He made the same argument about DCJ Raymond Zondo. He said he had reasonable apprehension to believe that he was biased, and that he believed that because he had sought to go to the High Court and bring an application to force Zondo's recusal, he should not be expected to appear before Zondo despite the ruling of the Constitutional Court. Interestingly enough, Kathy, he says in court papers that he now acknowledges that he should have brought some form of interdict application in the High Court to stay the subpoenas issued against him by the Commission, but says he did not do so based on poor legal advice, a clear swipe at his former lawyers. But interestingly enough, the inquiry coming out in court papers and saying it's not good enough for Jacob Zuma to attempt to blame his lawyers for his own decision in this regard. And interestingly enough, Kampepe spending a great deal of time in that judgment completely eviscerating Jacob Zuma's argument that this recusal application was somehow a defense against him being expected to honor the orders given against him by the highest court in the land.
We also see, Karyn, again coming out of the statement yesterday, the former president reiterating the fact that he believes his rights have been violated, and he continues to accuse the judiciary of bias. In fact, I want us to bring that bite up.
Contrary to the mainstream, the mainstream narrative and propaganda against me, I've never refused not to appear before the state.
All right, apologies for that incorrect audio clip there, but it was effectively of the former president saying that the laws in this country have been designed specifically to target him, and that legal processes, or at least the normal legal processes, do not apply to him. And what we heard from the Constitutional Court in their judgment last week is that the court had gone to great lengths to safeguard Zuma's rights. Let's listen to Justice Sisi Kampepe.
The Constitutional Court went to great lengths to safeguard Mr. Zuma's rights. Consequently, there is simply no sound, no logical basis on which Mr. Zuma can claim to have been treated unfairly or victimized. his attempts to evoke public sympathy through unfounded allegations fly in the face of reason and are an insult to the constitutional dispensation for which so many women and men fought and lost their lives. Having found that Mr. Zuma, like all alleged contemners in civil contempt proceedings, cannot be described as an accused person as envisaged in Section 35, and confident that a fair procedure has been followed to safeguard the rights to which Mr. Zuma was entitled in these proceedings, the majority holds that no Section 36 limitations analysis arises in the circumstances. The majority finds itself faced with little choice but to send a resounding message that this kind of recalcitrance and defiance is unlawful and will be punished.
Karyn, perhaps to go to tomorrow, of course, all eyes will be on the Pietermaritzburg High Court. It is precisely some of these matters that the former president has put before the Constitutional Court in that application for a rescission. But tomorrow, in terms of the stay of prosecution, what are we expecting?
Well, Kathy, this is where the rubber really hits the road, because on Wednesday, the Constitutional Court has ordered that the police must detain and commit Jacob Zuma to a prison facility if he has not handed himself over. The only way that doesn't happen is if there is some form of interdict or stay application that is successful on behalf of Zuma that prevents that from occurring. Now, we know the inquiry has gone on record and said that Jacob Zuma's application to get the High Court in Pietermaritzburg to stay his arrest on the orders of the Constitutional Court simply legally unsustainable, because the High Court cannot suspend the orders of the highest court in the country. Only the Constitutional Court can do so. It has invited Jacob Zuma to make such an application to the Con Court. As far as we know, he has yet to do so or has not done so. And the real question will be is if this, if the case tomorrow doesn't have some form of finality one way or another, and if there are still question marks as to what's going to happen, or indeed if the court dismisses Jacob Zuma's case and finds that, for instance, he doesn't, it doesn't have the jurisdiction to grant the relief he's seeking, what happens then? We know that his case will be heard on the 12th of July, but, the police will be violating an order of the highest court in the land if they don't arrest him on Wednesday, unless there is some form of legal barrier towards them doing so. The inquiry adamant that that needs to be from the Constitutional Court, but of course the High Court tomorrow will need to make a call of that, and there will be far-reaching repercussions either way.
Karyn Maughan, let's leave it there for tonight. Thanks for your time.